Merry Christmas, Happy Hanukkah, Happy Kwanzaa, Happy Festivus. I can't even remember what show that's from, but happy holidays, y'all, from #Lawyered. And we have a very fun holiday-themed episode for y'all today. So, listen up. Welcome back, everyone, to #Lawyered. You have your favorite legal A-team in the studio and in a very festive blazer.
Wearing my favorite jacket. So,
Austin, where did you even get this? It's like freaking reindeer puked on it.
Well, I feel like we need to get maybe some sponsorship money for this, but that's fine. Opposuits.com.
It's like oppa, like the Greek thing where they cheers. And
I think it's more like oppo, like opportunity. So you can wear them at. They make suits for specific occasions. So Christmas, holidays, St. Patty's Day, 4th of July.
St. Patty's Day. Yes, you would know that one.
Yes, I would. And because this is like a winter holiday themed blazer, and I tried to get one that was not specific to Christmas so I can wear it during the interim between Christmas and New Year's.
And I think that's appropriate. I mean, let's tell everyone what's on it. We got some freaking reindeer. We have Rudolph and all his friends.
Got a little royal blue undertone.
A royal blue.
Some nice red stripes, some snowflakes. Got a couple, just a lot of snowflakes.
And we've got some like geometric designs. Yes.
Yeah, I think they're supposed to be looking like snowflakes. But
yeah.
But yes, I try to wear this as often as I can.
Okay.
Company Christmas parties, random other holiday outings, family Christmas gatherings.
Are you wearing this to my birthday dinner tomorrow?
That's going to be a surprise. You'll just have to see. But yeah, I had to put it on for this show, of course. All
right. Well, you know what? I appreciate the festiveness. And y'all, I tried. I'm wearing a red blazer and my knockoff Gucci headband in red and green because, no one wants to pay full price for Gucci. Well, look, I'm kidding. There's no trademark infringement, I promise.
Typically, you're flashier than I am, so I had to try to church it up a little bit while we're in here today.
I know. I'm not sure. This is a little different. A little different today.
You don't like the beard, not like the jacket? You know what?
Okay, I guess I haven't given everyone a verdict on the beard. I like the beard.
Thank you.
It's grown on me. I like it.
No pun intended.
There you go. Anyway, so, y'all, joy to the world, the holiday season.
Absolutely.
Right? We all love to decorate for the holidays. We love to sing songs. We love to pop up a menorah or a Christmas tree on our desk. Maybe that's just me. But, Austin, what are some issues that come up during the holidays? Right? Because the holidays is not just easy living, stress-free. Right. And I'm not talking about visiting your in-laws, although I'm lucky my in-laws are actually super cool. So,
well, I think that, you kind of already alluded to it a little bit. A lot of people get very sensitive on the political correctness of what do you say around the holidays. But it's not just that. What we're going to talk about today is more about religion in government because that faces squarely on the First Amendment. And Christmas time, you do see a lot of that overlap because I say Christmas time, the holiday season. Sorry, I'm doing it right now. But the holiday season, it's a lot of it centers around holidays that have some form of religious underlying theme. And so we're going to run right into the conflicts of government and the restriction or encouragement of the religion as we talk about in the First Amendment.
Absolutely. And Austin, before we dive into this, I think our listeners have to have a firm understanding of the Establishment Clause. So,
absolutely.
What is the Establishment Clause? Take it away.
Well, the paraphrase version of it I kind of was mentioning is that the Founding Fathers, a little history lesson here, Founding Fathers didn't want to be told, or didn't want our country, men and women, to be told what religion they could practice, what religion they could not practice. And so the basis of the Establishment Clause is that government shall make no law abridging or establishing religion. It can't encourage religion. It can't infringe upon your freedom to practice what religion you want. That's the basis of it.
Thanks, pilgrims.
Right. Well, because the English church was such a big deal back in the day. It was a big
deal. And then you go back and then you have, Mary Tudor, Bloody Mary, going around like lighting Protestants up on fire because she was Catholic. Right. And then, finally everyone gets a break with, Queen Elizabeth. And she's like, y'all, I'm Protestant, but just you do you in your own private homes. I don't really care. Yeah. Just on your face, kind of be like cool, Church of England Protestant. Right. Yay, Queen Elizabeth. Peace out.
Well, the English government, the church was just another form of the English government oppressing the colonists.
Absolutely.
And so that's why we wanted to make sure everybody can practice the religion they want. And it's interesting because the turns that the Establishment Clause have taken throughout the jurisprudence of our Supreme Court have been interesting because
they're very colorful.
They are. And there's a lot of things where on the surface, you think, I don't see how this ties into religion. And you really have to get into the analysis to see, okay, now I understand why this is being challenged before the Supreme Court.
And as well, and I think a lot of people don't understand it, the Establishment Clause, it sounds very black and white on the surface, but in practice, right, it's really kind of complicated. And it's really dependent on just the facts of the situation.
Right, absolutely.
And so, but let's get into it, right? So, I love Christmas decorating. We've talked about the Establishment Clause. And we all kind of know Karen. Karen is going to make an appearance this holiday season.
I'm glad we're using that analogy.
Yes. No more Susie Q per your request.
Well, but Karen is a great person to put into this situation because she's highly sensitive, highly vocal, in the most inopportune and inappropriate times.
And we have a special species of Karen today. We have the know-it-all Karen.
Good.
Yeah, she's going to give the Krampus a run for her money this Christmas holiday season. Anyway, so know-it-all Karen, right? We have Diana. Diana works at the DA's office. She's an assistant DA, and they are going to decorate outside the DA's office for Christmas. Diana wants to put up a nativity scene. Know-it-all Karen, who is a staffer in the office, is like, oh my gosh, Diana, you should know better. You're an attorney. You work for the government. How dare you violate the Establishment Clause? You can't mix church and state. The nativity scene in front of the courthouse is not okay. And for context, Diana's friends are also putting up Frosty the Snowman, Rudolph the Reindeer, a menorah, a Christmas tree, and a bunch of giant inflatable snowflakes. So, what do we tell Know-it-all Karen? Because Diana's really nice, and she says, well, thank you so much for your input.
Right. Yeah. Well, first off, we tell Karen to chill out.
Yeah.
But
we tell all the Karens to chill. All of them.
But the Supreme Court, and I'll let you get into the actual the case itself, but basically the Supreme Court has said you can have a nativity scene which is Christian-based and is the Christmas holiday, as long as it's part of a bigger winter scene. It's not the sole focus. It's not the main image that people see, because that could be seen as the district attorney's office, an arm of the government, encouraging the Christian religion through the Christmas holiday.
Absolutely. So in the case that we are discussing here and that we got this ruling from, right, it's the 1989, love me a good 80s moment, y'all. If I had to come back into any decade, it would be the 80s. Oh, that hair. Anyway, so in Lynch versus Donnelly, it's our 1989 case where the court is explaining exactly what you just said, that yes, shocker, you can have a nativity scene in front of the courthouse. You could also have a frieze of the Ten Commandments on top of, actually, you know what? Forget the Ten Commandments thing. That was a different thing. You can have the nativity scene. You can have a menorah. You can have all these things out there so long as they are amongst a different display of secular objects. Because at that point, then the office isn't adopting a particular religious viewpoint.
Right.
They're saying, these are images of the winter holiday season.
Right.
Right? So yes, a nativity scene is something that pops up during the holiday season. And frankly, Christmas is extremely commercialized.
Absolutely.
Right? I mean, they get my money during the Christmas season.
Look at my jacket. I mean,
your freaking reindeers on that jacket. I'm still laughing.
Actually, this is a good example. We've got reindeer.
Is a great example.
We've got, very secular little images here. So
if you have all these secular images along with like the nativity scene and the menorah and what have you, that would actually be fine because you're not adopting, the DA's office isn't adopting a particular viewpoint. They're saying these are just images of a very commercialized holiday season that you typically see. So it's fine.
And I'd forgotten about this case until we brought it up. But it makes sense, right? Because you're not encouraging, but you get by telling someone you can't put a nativity scene up, you're kind of abridging the religion there. And so it makes sense that the Supreme Court got this way. Now, and of course, we see this in government buildings all over the place where they have these types of decorations up. But I think you are probably, just practically speaking, you're far more likely to see snowmen and Santa Claus and all that kind of stuff up because of what you just said, the commercialization.
Yes, definitely.
That's not really important for this point right now.
But speaking of commercialization, let's pivot this and talk about Christmas trees, right?
Okay.
So literally in the name, Christmas tree is like Christ.
Right.
And so I'm sure Know-it-all Karen is going to be like, oh, Diana, you can't have a Christmas tree in the DA's office. And then Say Karen goes down to the DMV to get another headshot for her driver's license because it expired. How unfortunate during the holiday season.
Yeah, that's really unfortunate. Getting on a plane, that's not easy to do,
That really sucks.
Anyways.
I hope she has a passport.
Right.
Guys, if you don't have a passport, get one. You should. Anyway, so she walks in the DMV and she sees a big old nice fake Christmas tree with a star on it. Actually, to make this example cleaner, let's take away the star and it's a bow.
Sure.
On top of the Christmas tree.
Yeah, a nice Christmas ribbon, red.
Yes.
On top of there. Perfect.
Because, commercialization of Christmas.
Right.
Presents and gifts. So, know-it-all Karen is aghast. She's like, oh my gosh, the DMV, I need to report you to the authorities. Even though, they are the authorities, but.
Yeah. Good luck holding them accountable, but go ahead.
Good luck. It's the DMV, right?
Right.
So, anyway, she's freaking out. Because there's a Christmas tree. And she's like, you can't have a Christmas tree. The word Christ is in Christmas tree, and that's religious. Separation of church and state and the Establishment Clause is being violated. Right? What are we going to tell Know-it-all Karen?
That's a lot for her to say at the DMV. I'll tell you that. I don't think the DMV workers are going to be very happy to hear all of that.
No,
They're just going to move her to the back of the line.
Probably.
But the fact is that Christmas trees are highly commercialized. I mean, and there's actually a case that you've referenced here that the county of Allegheny, thank you, versus the ACLU that basically says that numerous Americans place Christmas trees in their homes without any kind of religious belief behind that. And that makes sense. Think about the ornaments we see on a tree. And this is a good example of the Supreme Court applying practical society knowledge to their legal analysis. And it makes sense, right? Because they put them in, you see these trees in school holiday programs. They're in plenty of movies that we see all in our culture.
Absolutely.
That have no basis whatsoever in religion. Well, think about the whole story. Santa Claus, he puts presents under the tree. Santa Claus
Jolly old Saint Nick.
There's no religious belief behind Santa Claus, not that I'm aware of.
It's a German. No, it originates from, I believe, and y'all fact check me, I believe from a German fairy tale, I think.
Okay.
So
that's interesting. I didn't know that.
Yeah, I think so. And also, while we're talking about history, Christmas trees actually are, again, they didn't originate from baby Jesus at the manger. They actually originated. Right. Do you know the story?
I don't. I just knew that. I knew they didn't come from the manger.
Yeah, they're not. There are no evergreens
Nothing
in
the Bible there.
That time of year. No, so actually, Christmas trees originate. That tradition originates from Queen Victoria and Prince Albert and her family. So, way back during the Victorian era, Queen Victoria was actually, predominantly German. Actually, her mom was a German, some sort of nobility.
Okay.
99% sure. Anyway, so the Christmas tree tradition, I think started, if I am recalling correctly, again, fact check me, I think it started as a German tradition that Queen Victoria started doing with her family. And because Queen Victoria and Prince Albert and all their children were absolutely beloved by England, people started adopting what the Queen was doing with the Christmas tree.
Yeah.
And so that's how our Christmas trees, I believe, if I'm remembering correctly, Christmas tree tradition came to be.
Yeah.
So it's not even a religious origin.
Right. No basis in religion whatsoever. No. And I do think it's a good opportunity here. It's kind of a little tangent to just describe and discuss the ACLU for our listeners, because I use that acronym. So it's the American Civil Liberties Union, and they do a lot of things. But a lot of what they do is they're fighting for people's civil liberties, and usually it's a nonprofit organization that takes on cases, and usually they end up in the Supreme Court a lot.
Yeah.
And their idea is that you've got people who either can't afford to pay for the litigation that is needed to fight something that's infringing on their liberties, or it's a broad societal problem of some sort where someone's freedoms under the Bill of Rights are being oppressed. And so the ACLU will take that case on and litigate it for the betterment of individual rights.
Yeah, and they take a lot of test cases too.
They do.
Which is interesting because the ACLU has enough funding and backing to do that. So I always find it interesting the number of times you see ACLU as one of the party names when you get to the Supreme Court. And I'm like, this was a test case.
Yeah, exactly.
But they make, a lot of, not policy gets made, but a lot of landmark decisions are made this way.
Absolutely. Well, and it's helpful because, again, a lot of people, let's take the Christmas tree.
Yeah.
This exact case. Someone who, Karen, honestly. Karen's probably not going to put up the money to pay a trial lawyer and then an appellate lawyer and all these things.
She's saving up for a pair of Manolo Blahniks.
Right. Whatever those are. So
that's what these shoes are, buddy.
Okay, well, good. Now I have a better understanding of the props on our show now. And so, Karen's not going to front the bill for that.
No.
The ACLU will, so that those boundaries of the Establishment Clause can get tested and set by the Supreme Court.
And so, and whatever people's viewpoints on the ACLU, I think, if nothing else, what the ACLU does in terms of bringing cases to establish boundaries and identify the limits is helpful.
Absolutely.
Because it brings clarity to a lot of our very important rules.
Right.
And so, which I'm sure that's a very controversial statement. So we might get some DMs being like,
we might.
The ACLU. But anyway, all right. So now that we've had know-it-all Karen freaking out about nativity scenes and Christmas trees, let's bring it to the schoolyard.
Yeah, well, school programs are a big thing in elementary schools around the holidays. I mean, they always have been. They were that way when I was growing up. I'm sure you probably participated in some as well. It's a great experience for family. It's a joyous occasion.
Yeah.
And obviously there's plenty of non-secular, religious-based or religious overtoned Christmas songs that could potentially get sung in those environments.
Yeah. So, and I'm sure a lot of people wouldn't expect to hear when they go to their, what grade is an 8-year-old in? Like second grade?
Third?
Third.
I think it's third.
I obviously I don't have children,
Right.
so
right.
Second or third grade.
I deal with this when I'm dealing with our family law clients. I kind of get a better understanding because I get to think, okay, 8 to 9 is,
Yeah.
So
okay.
We're in the second and third grade.
Second to third grade area. Great. I'll defer to you on age situations now. So say we are Karen goes with her sister to watch her nephew Johnny in the school play. And it's a holiday school play, and the grand finale is all the children singing Silent Night. What does Karen do?
Karen freaks out.
Of course. Know-it-all Karen freaking out. What a surprise. And so she freaks out, right? Because Silent Night is a very traditional Christmas song. I mean, it's about the birth of Jesus and the nativity, right? I think I'm describing it correctly.
Yeah.
Okay. I do like it. I listen to the instrumental more than the actual lyrical version.
Right.
And so she's just freaking out because she's saying, again, oh no, Establishment Clause has been violated. This is a public school that Johnny goes to.
Right.
It's not a private Christian school. This is not okay. You can't sing this. Well, again, Karen is getting all worked up for nothing, shockingly. Because, dun dun dun, the Supreme Court has determined that schools may celebrate winter holidays, and they can even put up displays for the various winter holiday events, like Hanukkah or Kwanzaa or Christmas, as long as they do so within the context of the Christmas season.
Yeah. And
so, basically, you want to make sure that Silent Night isn't dominating the entire production, right? If maybe they've done a parody of It's a Charlie Brown Christmas and
Rudolph the Red-Nosed Reindeer.
Classic. And Frosty the Snowman, and then they toss Silent Night in because maybe the pianist really liked the the instrumental portion of it. So, okay, so that's an example of where the Christmas aspect, right, of Silent Night is just an element of a greater production that is not dominated by a specific Christmas theme.
Yeah. And I think the key there, and you said it a couple of times, is dominate. It can't dominate because then that shows that's kind of a promotion of religion. Whereas if it's just part of the entire equation, then we're just kind of letting it all play in there.
Yeah. And you can sing, a Hanukkah song in there too, as long as you, again, mix it up with these secular songs and there's not one religious song that's creating this dominating aspect.
Right. And it may be different, and I'm just going to make up this hypothetical on the spot, but it may be different if you have a very long, deeply religious hymn that's sung maybe for the entirety of the second half of the program. And maybe a better example would be all of a sudden we start working through the United Methodist Church's hymnal book in the second half of the school program. Probably a little bit of a bigger problem.
I think that would be a big issue.
Because now we're kind of flirting with the idea of dominating the overall presentations going on.
Absolutely. And I would definitely agree that would be very concerning in that situation.
Right.
And just, if people are kind of freaking out, they're like, oh my gosh, didn't even think you could do this, and they're interested. The case that really set this up is actually out of the 8th Circuit, and it's called Flory versus Sioux Falls School District, and that's a 1980 case. Again, the 80s. Love the 80s.
Well, and I think you had a point here in our pre-show outline that I think is important too, and it extends from what we've been talking about, that teachers, even in their classrooms, can put up decorations like a menorah and some other maybe nativity scene decorations.
Yeah, or a Star of Bethlehem.
Again, as long as there's not a overarching dominant theme in there. Now, I think probably most teachers would be conservative. They're going to put up Santa Claus and reindeer and presents
and snowflakes.
Trees. Yeah. But if they wanted to, they could, as long as we don't have front and center above the overhead projection screen the nativity scene, and then there's nothing else. That's takes up an 8-by-6 foot space on the wall. That would probably be an issue in a public school.
Yeah, and so long as also those displays are just temporary and within an educational context.
Yes.
So, and I think a really good example, right? So let's kind of swing into that school discussion. So say schools in their social studies program for elementary and middle schools, they have social studies, right? Social studies is the study of people and cultures.
Absolutely.
So a big part of people and cultures are religion. And so if you have Cindy is a teacher for, do they have social studies in 3rd grade?
I took social studies in 3rd grade, but that was a while ago.
Well, I'm asking you. You deal with young children more than I. All my friends who have young children, their babies can't talk yet. So
so candidly, in the family court setting, we don't necessarily get into the specific subject areas of what's being taught in 3rd grade. But let's assume it's still taught in Texas.
We'll assume so. So you have the social studies teacher who the week before their children's winter break wants to do a segment on the different religious holidays that make up the winter season.
Yeah, which makes a lot of sense. It's an idea of educating young kids so they're more tolerant, they understand what's going on.
Yeah, this is a great way to introduce the concept of Hanukkah and Judaism to children who maybe, let's be real, like, we are in Texas. It's predominantly, a Christian
Bible Belt.
Yeah,
we are.
Yeah, we're predominantly a Christian state, and that's great. But I think it's important for children to understand at a young age that there are other religions out there, like for example Judaism, and that requires tolerance and understanding and kindness. And what better place to start than at a young age learning that it's not just you celebrating Christmas, but your Jewish friends also have their holiday that they get to celebrate with their families. And so as part of this discussion, and maybe the teacher also wants to celebrate and discuss discuss Kwanzaa.
Right.
So say the week before Christmas, she pulls out a nativity scene. So one day they discuss the nativity scene, why it's important. Then the next day she pulls out, and the nativity scene is all in like paper cutout dolls.
Right.
Put it that way. Clearly very temporary. It's only up for that day while she's having this discussion with students. The next day, she pulls out a menorah, and she has that on the table to discuss, and they go over the tradition and the history behind the menorah, and then the next day, she has a Kwanzaa set up.
Yeah.
And they go over the history and tradition over the Kwanzaa table set. I'm sure know-it-all Karen would be losing her mind.
Right.
Losing it.
But again, it's kind of equal opportunity, putting it all out there. It's different than the teacher being at the front, leading a devotional and trying to tell the children they need to convert their beliefs to Christianity and take Jesus Christ as their Savior. Totally different vibe there, and that's what government's trying to avoid, right? Especially in a situation like that, you've got impressionable kids, you've got a teacher that has moral and position authority over them, and that's a microcosm of the government pressing the religion onto its citizens just from a classroom perspective, and that's what they're trying to avoid. They're not trying to keep the public school system from teaching our children about the different cultures and the religions that make up those cultures and all those kinds of things, because of what you were talking about earlier with tolerance and all the things that we should be preaching in our schools.
Absolutely. And they're trying to encourage our children to be culturally literate.
Right.
And let's take another example, right? Not just social studies, English class. So Bible themes show up all the time throughout the great pieces of literature. And I think, and I learned, right, we actually had to read portions of the Bible when I was in high school in order to understand all the various different allusions that a lot of classical literature was making.
I had the same exact experience about dealing with the different metaphors and things, because you can't read some of those texts without and understand what's going on and what they mean because of the metaphors and everything they put into it.
Also, for context, we read tons of Greco-Roman myths and legends, because that is also another area that is frequently alluded to. But, so for example, say we have teacher Cindy, and she is teaching her 3rd grade English class. Why not? Maybe they're very advanced students. And she pulls out the Star of Bethlehem, and she wants to talk about the Star of Bethlehem and the history and the culture, because it shows up a lot in a bunch of literature.
Right.
I mean, would she still be fine if she's just pulling out only the Star of Bethlehem, you think?
I would think so, because she's using it in the context of education, like you talked about before. I think another example that comes to my mind a lot is the story of the Prodigal Son.
Oh, yeah.
Because that's a common theme in literature.
Yes.
The Prodigal Son is a biblical story. Son leaves, comes back, and it's the return. The Prodigal Son is kind of a theme of the return of the son, basically. And that's a common theme in a lot of literature, because it's there's a storybook fashion to it, or there's a storybook value to it.
Yeah, absolutely.
Of a hero returning home kind of a thing. But you're using that as an aid to educate the children on these classic literatures and these writing styles. You're not using it to educate them on the birth of Jesus Christ as is told in the Bible. So the way you teach that is a different situation. And I think that it's interesting to me, this next case that we're talking about is the next scenario, I'll kind of just jump into it, is that the question you kind of pose is, can you sue a teacher or principal for not allowing a child or their parent to distribute religious themed gifts at school?
Well, let's back it up and give a hypothetical to make it real colorful.
Well, and I mean, I want to get into the hypothetical. I just think the question itself is like, oh wow, that's an interesting concept, because you're dealing with multiple layers of situations.
Right. Yeah. So we'll give the hypothetical, but this follows the actual fact pattern in the Morgan versus Swanson case, which is a 2003 case, pretty well. And that actually, interestingly enough, is out of the Fifth Circuit. 2003. It's a 2011 case. This happened in 2003.
Gotcha.
And so basically we have a school holiday party. It's not a private school. It's public and it's school sponsored. It's a holiday party. And it appears that both parents and children were invited. And one child wanted to pass out candy canes with a Christmas inscription or some such on the tag. So for our example, let's say it's cookies in a cute little cellophane wrapper with some Christmas ribbon that has like John 3:16 printed on a tag and attached to it.
Right.
Okay, so we'll use that example. Kid wants to hand it out to her friends. But the principal is like, hold on, kiddo. Wait, I can't have you handing out Bible verses at a school-sponsored holiday party.
Yeah.
Like, I don't care if it's Christian, Jewish, Muslim, whatever, Hindi, you can't do that. It's religion, and we're a public school. Well, then the parent gets really upset and says, hey, what are you doing? Like, my kid has the freedom to practice her religion however she wants. And then, the parent's like, well, then fine. If you won't let my kid give it to the other kids, I'm going to give it to the teachers. And the teacher or principal is like, hey, nope, can't do that. School-sponsored holiday event.
Right.
Not okay, buddy. And then then the parent is like, okay, well, fine, I'll sue you.
See you in court.
See you in court. Love that phrase.
I got to imagine, I don't know if we know where this is. I know it's in the Fifth Circuit, which for our listeners, the Fifth Circuit is the federal circuit that covers Texas as well as some other states as well.
Yeah.
And so it's local here. But I'd like to know where, like, I got to imagine this came out of some suburban.
Right.
I mean, look, I'm glad that we had the case because it tested, but I can just kind of picture who Mr. Morgan is and his persona. And anyways, I'll leave our listeners to be creative on that.
I'm sure Mr. Morgan comes from a nice house in the suburbs.
I'm sure his wife's name is Karen.
Oh, I bet it is. Karen Morgan, we're coming for you. No, I'm kidding.
So yeah, kind of walk us through what the court ended up saying about this, because it's interesting, and I know we try to stay away from procedural type things, but this is important for our listeners to understand.
Yeah, I feel like this one is really interesting because at first blush you would think, of course this makes sense. You can't distribute religious paraphernalia. I say that sounds bad. I don't mean it badly. You can't distribute religious items or messages at a secular school to one's peers or even consenting adults at a school-sponsored event.
Well, and the principal probably, I mean, you got to imagine in the principal's situation, he or she had to think, there's no way that this is like, I got to put a stop to this because I'm going to get in trouble for allowing it to happen.
And the principal doesn't want to get fired. I get that. I wouldn't want to get fired either.
Right.
You know, and so I'm sure the principal's like, look, just have your own holiday party and distribute them. Right. Or distribute them after
Stop
school.
Stop causing problems for me.
Yeah. Like, go across the street to Burger King and have, like, an early dinner and distribute them there. Yeah. Like, why are you doing it here? Right. Please don't get me in trouble. Please don't.
It's already the end of the semester, all right? We're already stressed out.
We're already tired. We're stressed. Kids don't want to do their exams.
Kids are all hopped up on sugar.
Freaking sugar, you know? Oh,
now you're giving them more and religious messages. Yeah. Thank you. Appreciate that.
You're causing me all sorts of problems, okay? Just let me be a principal. Let me do my job in peace. So, you know, that's probably the situation. And I'm sure the principal wasn't like, oh, I'm agnostic and this is offensive and I refuse to let you do it. No, he's like, just let me do my job.
Yeah.
Please. So anyway, Mr. Morgan did sue the principal. And the Supreme Court actually took what I thought was a really interesting turn. And the Supreme Court ultimately ruled it. I keep saying Supreme Court. It's the Fifth Circuit.
Fifth Circuit. It didn't go up to the Supreme Court.
It didn't go up. Not that I knew. That I know of. It went to the Fifth Circuit, which is interesting because most of these cases are like, you only see these like cases at the Supreme Court level. The Fifth Circuit doesn't deal so much with freedom of religion and stuff like that as much, right? Those are sexier cases that go up to SCOTUS.
Right.
Not Fifth Circuit as much. But here we do. So Christmas miracle, I guess, or Hanukkah miracle or Kwanzaa miracle.
Yeah.
I want to be inclusive. So anyway, the court ruled that, in fact, the principal's conduct actually was unconstitutional. Right. Which is interesting because the principal...
He was abridging religion. He was you know...
Abridging the practice of religion. However, gotta love sovereign immunity.
Yep.
Okay. And the court held that the principal was entitled to qualified immunity because the relevant law was too, I can't even pronounce this word, like abstruse?
Abstruse.
Yep. Abstruse and complicated for the principal to have known how to handle the situation. So that kind of blew me away, honestly.
It's rare. It's the first time I've ever read about it is in this situation.
I was pretty floored when I was reading this. I was like, what?
Because usually ignorance of the law is not an excuse for breaking the law.
Exactly.
Right. But I mean, it kind of makes sense of what we were talking about a second ago. The principal's saying, listen, these kids are wound up. We're just trying to get to winter break so all the teachers can go home without pulling their hair out.
Yeah.
And so, look, I just don't bring religion into the classroom, please. Just don't. It kind of makes, I mean, and I don't think the Supreme Court said that, or excuse me, the Fifth Circuit said that. I doubt that phrasing I just said is in the opinion. But, you know, it makes sense that this is a multi-leveled analysis that
absolutely
judges go through, and we're not asking an elementary school principal to have to figure that out on the spot.
Absolutely. And then also too, I think this goes and plays into not just the question of constitutionality, right? The practicality, like you were just describing, and also the concept of immunity. So the Fifth Circuit even went on to say that, look, I get where Mr. Morgan is coming from. Practice your religion how you want, but I'm going to tell you right now that suing a school teacher or a principal is not the way to go, because public school is an arm of the government.
Yep.
And so when the principal, right, Mr. Swanson, in this situation, Mr. Swanson was just trying to do the best he could, just like the situation you were giving. He's like, we're just trying to get to winter break.
Yeah.
Keep it calm, keep it moving. We're not trying to cause a fuss.
Right.
And so, you know, Mr. Swanson, I'm guessing, probably wasn't a lawyer. I would have to read the fact pattern again, but I don't think he was.
Right.
And so how is he to know the minutia of constitutional law about whether or not it's okay to allow this child to distribute, like, religious candy canes?
Yeah, well, and hell, I mean, even lawyers are going to say things like, well, it depends. And so even we have a hard time saying it's black and white. So there's no way in the world that we should be able to expect the principal to do that. And
absolutely.
And the interesting thing about the way the Fifth Circuit did this, and you and I praise this all the time when courts can do this, but they made a ruling, or they made a finding, they made an observation that yes, this was unconstitutional because he's abridging the practice of religion, but we're not going to hold him to the fire on this because of the qualified immunity. And so kind of was like, I don't know if this is the right terminology, but it's kind of the best of both worlds of, okay, look, we're going to give some guidance here with this case so that in the future, administrators know how to coach their employees on how to do this. But we're not going to punish him because it wasn't his fault that he didn't know about this.
And let's also explain what the concept of qualified immunity is for our listeners, because even some lawyers have a hard time understanding what qualified immunity is. Yeah. Right. So generally, qualified immunity is something you're going to see with government employees. Right. So for example, I guess we'll just stick with our scenario. Sure. No use throwing so many hypotheticals out there. But the qualified immunity is when a government employee, say the teacher, makes a decision doing her job, but she makes that decision in her discretion as a teacher, right? So she is choosing to, say, end the lesson early that day because the children are super rambunctious. And she's like, okay, let's go outside for recess 5 minutes early because you guys are about to start hitting each other.
It's going to make them tired and run it at them a little bit. Yeah.
Run it out and tire you out. So then tomorrow maybe we start class a little bit early and we can cover the 5 minutes that we missed. Right. You know, that's a very vanilla example of the teacher saying, I am trying to make a decision as a teacher on how to do my job the best way I can. Right. And so that's very similar, I think, to the principal in this situation who is saying, look, my basic understanding of separation of church and state means that we're not really supposed to have religious themed things at a public school. So I, in my decision as principal, whose responsibility it is to moderate this public holiday party sponsored by the school, is going to be no religious items. Right.
Carrying out his job. And so the court's not going to hold him liable for damages and things like that for carrying out his job within his discretion. Now, that would be different if the teacher in the same hypothetical decided that she was going to give the entire room a shot of Benadryl to try to knock these kids out a little bit.
That would be very different.
Not really in her discretion to do that. So we might have a different, little more fun, but different case that we'd be talking about at that point. She may be calling me for some criminal defense work at that point.
I know. So I don't think you can drug kids like that. That's really not okay. So absolutely. So again, and the court even said, look, it's almost impossible to successfully, there it is, sue a teacher or a principal for violation of First Amendment rights out of the school context when the teacher was just trying to do his or her job, or the principal. Right. So I think the Fifth Circuit was showing a good level of understanding the practicality of the situation while also marrying that with the procedural nuance of qualified immunity and the Establishment Clause.
So the moral of the story is give the teachers and principals a break.
Yeah. They're just trying to do their job.
Just trying to get the Christmas break here, guys.
Yeah. Just let them get to Christmas break. You want to have a big holiday party where you distribute John 3:16 cookies? Great. More power to you. That is awesome. Do it at your house. Yeah. Yeah, exactly. Don't put the teachers in that position. It's okay.
Yeah. And I think for me, kind of my big overarching idea with when I look at Establishment Clause cases, I can't say that I've ever read one that I feel like the court got wrong or that I disagree with. I think they've done a really good job. And I'm a huge proponent of separation of church and state. That's just a big thing that I think that I'm passionate about because I think it's really important. Yeah. And I think the Supreme Court and our intermediate appellate courts have done a great job really parsing that out and making sure that we're really encouraging tolerance by means of freedom of religion, no matter what religion you practice.
Absolutely. Absolutely. And that's something I think that's a really good note to end on, right, for this holiday season is that just tolerance, right? We discussed hate crimes in a prior episode, and I just think people need to understand. Just be chill. Yeah. It's okay. Like, people are different. People have different views than you, and that's okay. As long as they're not hurting people and you're not hurting people, just go live your best life, know? Not to be a hippie, but...
Right. Well, with everything that's gone on this year in the entirety of the world and in our country, it's a great time of year to reflect and think about those types of ideas like you just said, Andrea.
Absolutely. And just really focus on family and your family values, your religious values, and really cherish that time because 2020 was a crazy year. And you know what? We have to take and enjoy the small moments with family and friends when we can get them. Yeah. So, all right, y'all. we hope you enjoyed our extravaganza of establishment clause situations, and stay tuned for closing arguments.
Happy holidays, everybody, and go to Oppo Suits. And you're probably going to see more of these around different holidays moving forward, because I kind of having a good time with it, and I like to throw Andrea off a little bit.
I want to see the St. Patty's one.
Done.
Okay. Till next time, y'all.
Thank you guys again for listening to us here on #Lawyered. Go find us on whatever platform it is that you listen to your podcasts. Go like the podcast, go follow and subscribe to us. Leave us a review, leave us a rating. That helps us to really get the word out and really continue to tell you guys about all the different things that are going on in law and business here in Dallas. Make sure you check out our videos on our YouTube channel. It's #Lawyered. And then also follow us on our Instagram account. It's at #Lawyered. DM us, send us some issues, some topics you'd like to discuss, or some things that maybe you just don't understand about the law, because we want to make sure and cover and give you what it is you want to listen to.
Well. Welcome back to Closing Arguments, everyone. And today, Jake Paul, the very colorful, sometimes profane and obnoxious YouTube celebrity who has now gotten into a grand total of approximately 2 fights, has now had a beatdown of his own at one of his after parties. Apparently, his crew that he hired to work his party beat the snot out of a party goer, and now that party goer has turned around and sued not just the crew, but Jake Paul for negligently hiring and supervising these people. Will he win? I don't know. Let's see.